Good morning once again, class. I remain Dr. Bello Mohammed Magaji, an Associate Professor of Law, School of Law here in American University of Nigeria in Yola, Adamawa State. Today, in continuation of our law lecture series on Law of Contracts 201, week 2, we shall look at the formation of a contract. We shall look at formation of a contract, and we shall look at 5 aspects of this topic. We'll look at what is an offer, an acceptance. We'll look at intention to create legal relations, consideration, capacity to contract, and legality of the contract. As I said again, I will repeat, we'll look at offer and acceptance, intention to create legal relations, consideration, capacity to contract, and legality of a contract. As I say, these are issues that have to do with the formation of a contract. Now, there is a preamble to the formation of a contract, which is that the formation of a contract is a fundamental aspect of a contract, governing the creation of legally binding agreements between parties. It also involves the coming together of offer, acceptance, consideration, and intention to create legal relations. Now, the process of contract formation is guided by both what? Judicial decisions and statutory authorities. Now, let us look at what is an offer. What is an offer and the position of an offer in the formation of a contract. Now, a simplistic definition of an offer is a proposal made by one party, that's the offeror, to another party who is the offeree, indicating a willingness to enter into a legally binding agreement. I will repeat what an offer is, where I say it's a proposal made by one party. The party making the proposal is who we call the offeror, and then to another party who is accepting it, who is called the what? Offeree, indicating a willingness to enter into a legally binding agreement. Now, an offer must be communicated to the offeree and must contain certain definite and certain terms. The intention of the offeror to be bound by the terms of the offer is essential for it to be considered a valid offer. The offeror must be willing that this offer is making, he is bound by it and is legally bound by what he is about to do. Now, the offeror has the power also to revoke or withdraw the offer at any time before the offeree accepts it, unless the offer is irrevocable due to an option, contract, or reliance by the offeree. Now, as I have said, let me still round up as what an offer is. We say it's an expression of willingness to enter into a binding contract on certain terms once it is accepted by the person at whom the contract is intended. Now, we have some cases that support this proposition I have made with regards to the meaning of an offer. The case of Orient Bank Nigeria Nigeria PLC versus Bland International Limited. We also have the case of Benue Cement Company PLC versus Sky Inspection Nigeria Limited. These 2 cases are judicial authorities as to what an offer is, as I have mentioned earlier on. Now, there are two parties to an offer, as I have said. We have the offeree and the offeror. We have the offeree and the offeror, which I have explained earlier on. Now, let us look at the forms an offer can take. We've looked at the parties. We have forms an offer can take. It could be bilateral, it could be unilateral. Offer will take two forms. It could be what? Bilateral offer or unilateral offer. Under unilateral offer, we are coming to look at the case of Khalil versus Carbolic Smoke Ball Companies, an old English case reported in 1893. Now, having said that, I think we can look at the essentials of a valid offer. Now, there are certain essentials for a valid offer. One, it must be precise and unequivocal. Two, there must be clear intention to be bound by the offer. The third, it must be communicated to the offeree. Four, it may be general or specific. Next, it may be express or implied. In that case, also, we have the intent, certainty, and specificity of the offer. So these are essentials of a valid contract. There are 6 items I have mentioned here that are essentials of a valid contract. Now, I want us now to differentiate between an offer and an invitation to treat. These are two different concepts in the law of contract, and it is important to draw a line between what is an offer and what is an invitation to treat. We've seen that an offer is a quite clear, unequivocal proposal by one party to another in such a way that they are bound by the offer if accepted by the person to whom it is made. Now, invitation to treat is a different issue at all. I mean, it's a different issue in the sense that it is not an offer, but like a proposal, a solicitation for an offer towards making a contract, like a negotiation statement prior to a certain offer, and this is not capable of being accepted. Just like trying to talk somebody into accepting an offer. It is not an offer, but it's just like a negotiation, as it were, leading to an offer. Now, let me give instances of invitation to trade. One, auction sales, and the cases in support of the fact that auction sales are invitation to trade and not an offer are the case of Pine versus Cave. It's a very old case, 1789. And then the case of Adebayo versus Konde is a case reported also in 1938. Now, this shows that auction sales are not what? An offer, but an invitation to trade. The second category are display of goods. Display of goods at a shop. Is it a shop? A ShopRite, as it were, or Leventis, or whatever shopping complex you have. If you display goods on a shop or at a shop, they are not offers but invitation to trade. And the cases in support to this are the case of Fisher versus Bell and the case of Pharmaceutical Society of Great Britain versus Booth Cash Chemist Shop. This is a proposition that display of goods are not offer but invitation to trade. Another category of invitation to trade are advertisements and catalogs. Now, you see advertisement every day, either on the newspaper, on the radio, or wherever you see an advert, or on bills or catalogs. These are all what? invitation to trade. And the proposal, the cases in support of this is the case of Garang and Sons, Garang and Sons versus Gu. It's a very old case, 1896, reported in appeal cases 325. Of course, you need to compare the adverts with the case of Khalil versus Kabuli Small Ball Company. Now, also, invitation to tender is not an offer, but what? An invitation to trade. Every day, big companies or whatever companies there are, call for tenders. All these tenders, once submitted, are not offers, or once they are on display, they are not offers, but what? Invitation to trade. Another category are tickets that you buy for a cinema show, for football, and so on. These are all what? Invitation to trade. It is at the point of acceptance of the tickets for you to enter to watch the acceptance, the offer is made, because at any time before the show, the tickets or the offer, as it were, can be cancelled, and you cannot say that an offer has been made to you. Now let us look at a very peculiar case of cross offer. Now, cross offer is an offer made by parties to each other on identical terms in ignorance of each other's offer. We call it cross because they cross themselves, as it were, on the road, because the offeree is making an offer unknown to him that an identical acceptance has been made by the offeree. So they are cross in terms of the intention of the two parties. So in that case, there is no meeting of the minds, because they are two identical. One is thinking that what he is talking about is an offer, whereas the other is also accepting what is different from what the other person is offering. So we say this is a cross offer, and there is no meeting of the mind. In law, we call it consensus ad idem. There is no meeting of the mind. So there is no contract where cross offer is what? Established. And the judicial authority for this is the case of Thorn versus Hoffman and Co. It's an old case also reported in 1873. Now there is another category of counter offer. We've discussed cross offer. This is counter offer. Simply put, counter offer is a rejection of an offer by varying the terms. When we say counter, is when an offer is made, I want to buy, or can you buy my red car for 10,000? You say, I will buy your red car for 9,000. Already you have counter the offer. The offer is for 10,000. You are saying you are accepting for 9,000. So it's a what? Counter offer. So counter offer is like a rejection, because you have varied the terms of the offer. And once you've varied the terms of the offer, it means it goes to show that you are not accepting the offer based on the original proposal made to you. And then, of course, the case of Oren Bank versus Bilante, which I have earlier on said, and then the case of Solel Bone Nigeria Limited versus Kanta International Company Limited are the judicial authorities for the proposition that counter offer is variation of the offer. And then what is the position of the law? The position of the law is that you have rejected the offer. It is like a form of invalid acceptance. It is not an acceptance, it's an invalid acceptance. There is no meeting of the mind, and then it comes in form of qualification of the offer term, which varies or alter the term or introduce a new term into the proposal earlier made. So it amounts to what? Disqualification. It amounts to rejecting the offer, as it were. And the case in support of this is the case of Hyde versus Wrench. It's a very old case, 1840. It's an 1840 case. Now finally we look at electronic offer in modern terms now, unlike what used to happen there where things were analog as it were. Modern terms involve technology, so offers are made now electronically. Electronic contract involves entering into a contract by means of, say, WhatsApp, internet, Facebook, and all forms of telecommunication which are available in modern technology. Now all elements of the traditional law of contract, the traditional offer and acceptance which I have mentioned, are also required in this modern technological age. However, it's a little bit complicated compared to the traditional system. For instance, at what stage do you say an offer has been accepted? At what stage do you say you've made the offer and all that? There are so many issues involving the offer and acceptance in modern technology, which makes contract law a little bit more complicated, as it were, and then most of the cases that we have could, for one reason or another, be modified because of the speed in technology and all that stuff. Good. Now in the technology also, for instance, the display of goods also qualify as an invitation to treat, and then also the whereby the purchaser will make the offer by clicking on the goods or services he desires. So there are a lot of, as I've said, there are a lot of issues revolving contract law in technological age, which the law is developing, hopefully to a more certain time. Now, let us look at the termination of offer. How does an offer come to an end? We have the following means. One, by revocation. Revocation, where you revoke the contract, as we've said, we've given instances where for you, the person who is making the offer revokes it, but it has to be communicated, and then the revocation must be, as I've said, must be communicated. Now there are lapse of time. If an offer is made to you, and then there is a time limit, and then the time limit crosses, then there is the offer will terminate. Death of either party, in contract law, death of either party brings to an end the contract. So the same with offer. Rejection, if you reject an offer, rejection can be by cross offers, as we've said, or by a cross offer, yes, or by making an additional variation to the original offer, as we have seen earlier. So cross offer can mean a rejection of the offer, or you make another offer on top of another person's offer. It will amount to what? You are rejecting the offer. Thank you very much.